This is the issue, and I am the ghetto man. Today's issue, your right to represent yourself in court, and also your right to counsel and your right to counsel of your choice. Did you know that 90% of all trial lawyers are incompetent? Well, we will answer that question in just one moment. We'll be right back. All right, we're back. In 1977, while speaking to the American Bar Association, then Chief Justice Warren E. Burger said that 90% of all trial lawyers are incompetent. Can you imagine? 90% of all trial lawyers are incompetent. What do you think your chances are of finding effective counsel for your defense, like Googling on the internet? How many people do you know that can afford to retain a high priced attorney? Well, Berger's statement alarmed me. After giving his statement a great deal of thought, I came to the conclusion that if I were going to represent myself in a lawsuit, the first thing that I had to do was learn enough about the law to become incompetent. Then I would be equal to at least 90% of all trial lawyers that I would encounter in any court. Now, what Berger didn't say, and this is really important, is that all trial judges come from the ranks of trial lawyers. Now, logic would dictate then that 90% of all of the trial judges that you're going to encounter are incompetent as well. Now, people are getting fed up. They're fed up with the legal profession. They're tired of spending their hard-earned money on incompetent lawyers. This is why, in courtrooms all over the United States, we're beginning to see more and more citizens like myself acting as their own attorneys. Now, the Latin word for this is in propria persona, which means in one's own proper person. Well, what is an attorney? An attorney is an agent acting on behalf of another. And why do we need attorneys? Well, the biggest reason is that most people don't know how to utilize the courts without one. And why don't people know how to utilize the courts? Well, the answer is very simple. We were never taught in our government school system how the court system works. It was left a mystery so that all of us would have to depend on an attorney for our legal needs. Does a person really need an attorney when he or she has a legal problem? Absolutely not. Why? Because a citizen has a constitutionally protected right to represent themselves in court. And as the cost of legal services rise more and more citizens are exercising this right every day. Unfortunately, when a person decides to use the courts, they are forced to endure a prejudicial judicial system that is so discriminatory against any person that would dare exercise his rights to represent himself. Prejudice, I found, greater than that of the Democratic Party's Ku Klux Klan in the South against the rights of black Americans. I call it black robe prejudice, and its roots can be traced back to the inception of our country. Its origins come from a closed shop situation created by a public corporation called the Bar Association. The Bar Association is an organization of lawyers that caters specifically to the legal profession. This elite group looks down on any citizen that dares to exercise their right to represent themselves in a lawsuit. The Bar Association will stop at nothing to discourage a person from utilizing the courts and taking counsel with anyone other than a licensed attorney. Because of this, it is virtually impossible for a person representing themselves to find a courtroom where they will be treated like the sovereign they are. Rarely will you find a trial judge that can remain impartial in a case involving a pro se litigant. In all the years that I have been representing myself, I've only met one judge at the trial level that was not prejudiced against a pro se litigant. She was the chief judge of the Municipal Court of Long Beach, California, and I salute her. She was an honor to her profession. But in most cases, the judge will do everything in his power to harm you and your case. Why? To protect the reputations of his brothers of the bar and their religion. Now, over the years, I have been ruled against arbitrarily, held in contempt of court. I've been jailed, fined, and anything else that could be done to humiliate me in front of my peers. Why? To discourage me in my efforts to obtain justice. Thank goodness for the appellate courts back then. And I say back then because a person could get relief or protection or at least get their case reversed from an appellate court justices. It was the only relief you had from a corrupt, prejudicial trial court judge. For the most part, that doesn't happen anymore. When a person decides to act as their own attorney, they soon discover, in short notice I may add, that the attorneys in their area, especially the insecure ones, will try everything in their power to keep us out of their courts. Attorneys have a difficult time understanding the law as it pertains to a person's First Amendment right to freedom of speech and freedom of association. Freedom of speech, freedom of association, these two rights are extremely important in a free society like we're supposed to have. Without these two rights, you might as well go to court with a gag on. There's no way that you can properly prepare and conduct any court proceeding without freedom of speech and freedom of association. The legal profession thinks that the right to freedom of speech and association ends the moment you enter a courtroom or when you choose to if you choose to talk about the law with other people. This phenomena has always intrigued me. As good citizens, we're all supposed to know the law, right? I mean, remember, ignorance of the law is no excuse. Well, in the eyes of the Bar Association, this right evaporates when a person decides to talk to a friend or a neighbor about the subject of law, just like we're doing right now. You better watch out. The big brothers of the bar might be watching. Over the years, I have found that every time I start teaching people about their rights and the law, someone in the legal profession wants to have me charged with practicing law without a license. And this most commonly occurs when I start working with other pro se litigants or when I publish a newsletter or create a show like this one. Well, for the benefit of all the lawyers and judges out there that might happen to view this show, relax and enjoy. You might learn something. You know, American history tells us that lawyers are the kiss of death and should be forever banned from our land. I assume that's why most pro se litigants share the same virtues and self-reliance and the traditional distrust of lawyers that the colonists did. When the colonies were first settled, the lawyer was synonymous with the cringing attorneys general and the solicitors general of the crown and the arbitrary justices of the king's court, all bent on the conviction of those who opposed the king's prerequisites and twisting the law to secure convictions. This prejudice gained strength in the colonies where distrust of lawyers became an institution. Several colonies prohibited pleading for hire in the 17th century. The prejudice persisted into the 18th century as the lower class came to identify lawyers with the upper class. The years of the Revolution and Confederation saw an upsurge of anti-lawyeril sentiment, a sudden revival after the War of the Revolution of the old dislike and distrust for lawyers as a class. In the heat of these sentiments, the Constitution was forged. And this comes from a Supreme Court case called Ferretta versus California, found in Book 422, U.S., page 806. Now, in Ferretta versus California, the Supreme Court set the guidelines for pro se litigation. Ferretta recognized that the right to self-representation had been protected by statute since the beginning of our nation. In all courts, the United States, the parties may plead and manage their own causes personally or by the assistance of counsel. Once again, that's from Ferretta versus California. The key question before the Ferretta court was whether the state may constitutionally hail a person into its criminal courts. We're talking about criminal law at this time, and there force a lawyer upon him, even when he insists that he wants to conduct his own defense. The court concluded that the state may not constitutionally do so. In order to clarify the right to assistance of counsel and the right to dispense of a lawyer's help, Ferretta explored the historical developments surrounding the subject. For example, the 1776 Pennsylvania Declaration of Rights said, either party has a natural right to plead his own cause. This right is consistent with safety. Therefore, it is retained, but the parties may not be able. Therefore, the civil right of pleading by proxy, that is by counsel, is an appendage to the natural right of self-representation. Thomas Paine, on a Bill of Rights, 1777, that's reprinted in 1 Swartz, 316, and it was also cited in this case, Ferretta versus California, found on page 830, footnote 39. There is no evidence that the colonists and the framers ever doubted the right of self-representation or imagined that this right may be considered inferior to the right to assistance of counsel. To the contrary, the colonists and the framers, as well as their English ancestors, always conceived of the right to counsel to be used at his option in defending himself. And that once again comes from Ferretta versus California, on page 832. But it is one thing to hold that every defendant, rich or poor, has the right to assistance of counsel, and quite another thing to say that a state may compel a defendant to accept a lawyer he does not want. Ferretta versus California again, page 833. Now, after taking exhaustive historical note on the issues of the right of self-representation and the right of representation by an attorney, the court went on to recognize the inalienable right of one to plead and manage his own cause personally. And this is very important, because if you're going to manage your cause and you have a right to, you have a personally right to manage it the way you want to, providing you're not, disrupting the decorum of the court or violating any particular rules. Okay, contrary to the popular belief of most attorneys and judges, the independent right to plead and manage one's own cause does not waive a person's right to the assistance of counsel guaranteed by the Sixth Amendment to the United States Constitution and the co-related rights retained by the people guaranteed by the Ninth Amendment to the United States Constitution. Such a result would sever the concept of counsel from its historical roots, such as lay counsels, somebody other than a licensed attorney. Yeah, what about lay counsel? Counsel that you can choose that is not a member of the bar. The first lawyers were personal friends of the litigant, brought into court by him so that he might take counsel with them before pleading. One F. Pollock and F. Maitland, and that was also cited in Ferretta versus California, page 820. The Massachusetts Bodies of Liberty in 1641 In Article 26 provided that every man that findeth himself unfit to plead his own cause in any court shall have the liberty to employ any man against whom the court doth not accept to help him, provided he give him no fee or reward for his pains. Feretta versus California, 827. And that in all courts, all persons of all persuasions may freely appear in their own way and according to their own manner, and their personally plead their own cause themselves, or if unable, by their friends. That's very, very important. That's 1B Swartz, The Bill of Rights, a documentary history, 130, 1971. And that was also cited in Feretta versus California on page 828 and footnote 37. A person's right to take counsel with a layperson, this in court overlaps. This overlaps with the right to self-representation. If a pro se litigant chooses to have someone other than a licensed lawyer assist him, it's well within his right to self-representation to do so. Feretta relied on the well-settled doctrine in a case called Powell versus Alabama, and that will be found in 287 U.S., page 45, which guarantees a criminal defendant the right to assistance of counsel of the defendant's choice, not counsel of the trial court's choice. Now, for some reason, trial court judges can't seem to grasp this concept, or maybe they're just protecting their fascist corporate closed shop monopoly bar association friends. Feretta also relied on the well-settled doctrine that can be found in Johnson versus Zerps, Z-E-R-B-S-T, Zerps, 304 U.S. on page 454, which provides that the right to assistance of counsel cannot be waived unless done so knowingly and intelligently. A competent pro se litigant will always refuse to waive his right to assistance of counsel and demands that the court recognize his next friend as counsel at all of the proceedings. A citizen has a constitutional right to effectively present his own defense, as long as the pro se litigant remains the attorney of record and is managing his own defense. It doesn't matter who is at the counsel table with him. The accused must have the means of presenting his best defense. Essential fairness is lacking if an accused cannot put his case effectively in court. And that comes from a case called Adam versus United States ex rel. McCann, 317 U.S. at page 269. That's where this case starts. More and more citizens, like me, are appearing in court in propria persona every day. In conducting their own defense, they are demanding that the trial court recognize their right to self-representation, which includes persons, sometimes trusted friends, that they have chosen to take counsel with them during all the proceedings or a trial. Their counsel of choice. The idea of lay counsel is not new to our courts. Laymen should be allowed to act as next friend to any person in the preparation of any paper or document or claim, so as long as he does not hold himself out to be as practicing law or as being a member of the bar. And that's another Supreme Court case, Johnson versus Avery, 393 U.S. at 483. The position that most trial judges take when dealing with a pro se litigant is that the court, can choose for the defendant who can or cannot assist him in his defense, or at least force an unwanted lawyer upon him if he chooses to have counsel. This discriminatory action renders a citizen's right to self-representation null and void. His defense is no longer his. It is that commanded by the court. His right to be heard through his own counsel is unqualified. And that comes from Chandler versus Freetag, 348 U.S. 3. And so the courts always want to try to qualify the word counsel. Well, what I was going to say there was something to the effect that all attorneys are counselors, but not all counselors are attorneys, if that makes any sense to you. See, when a citizen is hailed into court, their right to freedom of speech and association, their right to peacefully assemble, their right to freedom of religion, and their right to freedom of speech are not suspended when they pass through the short swinging doors upon entering a courtroom. This right is protected by the First Amendment of the United States Constitution. A state could not, by invoking the power to regulate professional conduct of attorneys, infringe in any way the right of individuals and the public to be fairly represented in lawsuits authorized by Congress to effectuate a basic public interest. Laymen, like myself and most people that I know, cannot be expected to know how to protect their rights when dealing with practiced and carefully counseled adversaries, and for them to associate with each other, to help one another, to preserve and enforce rights granted to them under federal laws cannot be condemned as a threat to legal ethics. Now that can be found in a Supreme Court case called Brotherhood of Railroad Trainmen versus Virginia XLRL Virginia State Bar. That can be found in Book 377 U.S. 1. Today, trial courts insist that if an accused wants to plead and manage his own cause, he will have to proceed alone, without any help or insistence whatsoever at the counsel table. Now, it's quite common for an attorney to utilize the help of an assistant in court and at the counsel table. I observed such activity many times, which have included assistance of co-counsel, assistance of a researcher, assistance of an investigator, assistance of a paralegal, assistance of an expert witnesses. I mean, the list goes on. And often these assistants are not members of the bar. Must we continually remind the brothers of the bar that the power of an attorney comes directly from the accused? It isn't the other way around. And how can an attorney possess more rights than the accused himself? Well, of course he can't possess more rights. Excuse me. This twisted form of logic runs counter to the fundamental rights of justice. And this brings us to what I consider the most important part of pro se litigation: a person's sincerely held religious beliefs, and how it affects the right to counsel of choice. Most of the pro se litigants that I know personally share the same feelings that I do about the legal profession, that all lawyers, including judges, because they too are really lawyers, are bent on convicting citizens who appear and desire to appear in propria persona and exercise their constitutional rights. When it comes to the pro se litigant, judges and lawyers alike are no longer concerned about justice. They twist the law, destroying all of our traditional values, and then use it to secure convictions against innocent, law-abiding citizens who dare to enter the courtroom without one of their brothers of the bar. This is why most pro se litigants share the same virtues as our great men that founded our republic. Our nation's founding fathers brought to this land biblical principles. These great men had the foresight and the intestinal fortitude to incorporate these biblical principles in the very foundation of our Republican form of government. The early justices of the Supreme Court understood these principles and declared that the United States of America is a Christian nation. And that can be found in the Supreme Court case called Holy Trinity Church versus U.S. And that's Book 143 U.S., page 457. That goes back to 1892. And also McGovern versus Maryland, 366 U.S., 420. The reason why I'm bringing this up is because it's very important that we just keep the history accurate. Like I've told people before, I'm not a Christian, so I'm not pushing Christianity, but this is a prime example of your First Amendment rights of religion and how it affects you when you go to court, and when the court denies you certain things that are mandated through your religious beliefs, that the court has to recognize those things whether they like it or not. And I said the only two things you really the court should be concerned about at any time is whether or not, you're disrupting the decorum of the court, or you're not following the same rules of court as anybody else that would have to enter their courtroom, whether it be an attorney or a private person. Well, anyway, quoting from the Bibles, but the Pharisees and lawyers rejected the counsel of God against themselves. Luke 8:30. Now, biblical concepts, whether you agree with them or not, can be found in our law as late as 1982. It was a law passed by Congress. It's called Public Law 97-280. It was passed October 4th, 1982, and basically proclaiming 1983 as the year of the Bible. Now, this little-known law goes right to the roots of our Republican form of government. Public Law 97-280 states, whereas the Bible, the Word of God, has made a unique contribution in shaping the United States as a distinctive and blessed nation people. Whereas deeply held religious convictions springing from the Holy Scriptures led to the early settlement of our nation. Whereas biblical teachings inspired concepts of civil government that are contained in our Declaration of Independence and the Constitution of the United States. Whereas many of our great traditional leaders, among them President Washington, Jackson, Lincoln, and Wilson, paid tribute to the surpassing influence of the Bible in our country's development, as in the words of President Jackson, the Bible is the rock on which our republic rests. Wherein the history of our nation clearly illustrates the value of voluntarily applying the teachings of the Scriptures in the lives of individual families and societies. Whereas this nation now faces great challenges that will test this nation as it's never been tested before, and whereas that renewing our knowledge of and faith in God through the Holy Scriptures can strengthen us as a nation and a people. Now, therefore, be resolved by the Senate and House of Representatives of the United States of America in Congress assembled that the President is authorized and requested to designate 1983 as a national year of the Bible in recognition of both the formative influence the Bible has been for our nation and our national need to study and apply the scriptures teachings of the Holy Scriptures. Okay, any person that has studied the Bible recognizes the great influence it has had on our republic. There's no argument there. And when I'm going to get into some shows where we're going to go through and really show you how important this issue is. Not so much, once again, for religious purposes, but really it's important historically, because you have to know the truth of your history if you're expected to be able to understand what is going wrong today. Okay, in fact, the Bible is a history book, isn't it? In it, it refers to lawyers as hypocrites, that lawyers have taken away the hidden knowledge from the people of this nation. So, rightfully so, when Yeshua said, "Woe to you also, you lawyers, for ye laden men with burdens, grievous to be borne, and ye yourself touch not the burdens with one of your fingers." Luke 11:46. And then he repeated his woe when he said, "Woe be unto you, lawyers, for you have taken away the key of knowledge. You enter not in yourself, and them that were entering you hindered." That's Luke 11:52. So lawyers they've had a bad rap for a long time. These people are, just to go on with this show, uh, the the importance of your right to self-representation and your right to counsel of choice, I can't stress it anymore. Even though the Sixth Amendment deals with your right to a speedy trial and all that stuff, and we're going to cover that later on, when it comes to your Sixth Amendment right, this is the key. This is the core. It's been the courts are so corrupt that at this stage in time, you can't do anything unless you play by their rules and their rules only, and they can bend them whenever way they want to, and judges can do things, and they can literally get away with murder. Now, when a person who lives their life according to biblical principles utilizes the court system and does so in propria persona, it's a proper person, and chooses to take counsel only with other persons who live their lives according to biblical principles, the courts cannot deny that inalienable right. And you want to proof of that is the United States versus Seeger, which is a Supreme Court case, 380 U.S. 163. And it says a person cannot be forced to act contrary to his sincerely held religious beliefs. To do so would compel him to waiver his religious beliefs in order to obtain counsel or another. In other words, they're telling you if your religious beliefs won't let you use a licensed lawyer and you decide to use your next friend as counsel, they're telling you, and you're doing that because of your sincerely held religious beliefs, they can't come along and say, well, you have to give up that religious belief and take a licensed lawyer. They can't do that. You cannot be forced to give up one right in order to have a right to counsel. You have a right to counsel of your choice, not their choice. In other words, a person cannot be forced to waive one right in order to obtain another. A citizen's right to freely associate, assemble, or speak with persons they depend upon in assisting them with their defense cannot be suspended by any law or any statute in any court in the land, providing those persons assisting them do not hold themselves out to be attorneys. It is only through vigilance that we can remain a free people. We, the people, are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who pervert the Constitution. That was Abraham Lincoln said that. Okay, so let's just do a quick overview of what we're talking about here. Well, first of all, we're talking about your right to represent yourself in court, which everybody agrees you have a right to do so. But that right does not mean that you've waived your right to have assistance, a counsel of your choice, because we've learned that counsel doesn't have to be a licensed attorney. It can be just your friend. And let me give you an example here, how important this is. Okay, you're sitting at counsel table. I'm the defendant. I'm the attorney of record. I'm the one who's handling the case. I'm representing myself. Okay, and I have a guy next to me here that I know is really learned in criminal law, and he really understands this particular aspect of law better than anybody I've ever known. So I want to talk to him. I want to freely, my right to freedom of speech and association, I want to associate with my friend. Now remember, I'm the attorney of record here, but I want to associate with my friend. So I tell my friend, what do you think? Give me some ideas here, what I should consider. And the guy says, well, I don't know. And he goes through a few things, and I sit there and listen to him, and I say, okay, I don't think that's a good idea. I don't want to do that. But this sounds like this is going to be a good idea. I'll work with that. Now, see, this is it. He didn't advise me what to do. What he did is he counseled me and he told me what he knows about it. I took that information and I decided whether or not I was going to accept it and reject it. And if I decide to accept it, then I'm going to present that. I'm going to be the one that presents it. This man's not representing me. I'm representing myself. But I still have a right to take counsel with this person. And then what if I need an investigator has to investigate something, or I need somebody who's going to, run back and forth, maybe type up some motions and briefs while I'm busy, fighting a battle in court. What if I need that stuff? Today, when you go into court, the judge will tell you, no, you can't have anybody at a counsel table. While your opponent, a lawyer, has all these people at the counsel table with him. And they're doing this and talking about that, but you've got to sit there and you're not allowed to do anything if you're representing yourself, and you don't have a right to take counsel with anybody. Every single time that I have brought this particular issue up on appeal, the appellate courts have never, not one time, have they ever addressed the issue that I had there, my right to assistance account. Read the Sixth Amendment. It says assistance account. It doesn't say your right to be represented by a lawyer. And as we've shown you, going through these various different cases, it's clear that a person's right to represent themselves includes taking counsel with everybody you want to. You can freely associate, freedom of speech, you have freedom of assembly. You can be whatever you want. And these judges will tell you that you can't bring it into the courtroom. They completely violate every bit of your First Amendment rights. Then they violate your Sixth Amendment right, of having counsel of your choice. And they do this with impunity. This is why I've told you that the judicial branch of government is by far the most corrupt. It's completely controlled by the corporate bar association. And we've talked about this over and over again. I can't stress this more. Once again, you have a corporation, a bar association, which is using the power of government, the courts, to be able to keep everybody out of there that doesn't follow their rules, and stripping everybody of their constitutional rights arbitrarily. I mean, what right does it? What does it hurt to judge if I have somebody sitting next to me and I'm talking with them and we're helping me with my notes and stuff, and they might be taking notes, and I want to look over and see a note. Or I can't I can't do both at the same time. I need somebody that's going to be able to do that, and to be able to point out to me some important topics that we both know that I should discuss. Oh yeah, I almost forgot about that. That is something that is so important if you're representing yourself in order to win a case. So this is why there's going to be 3 shows with this. The next show is I'm going to reading directly from a brief that I filed with the court on this particular issue. And it's a little bit, it's going to be a little bit more of the legal writing, but I want to share it with you because this is such an important issue because the Bill of Rights, I want to sit there and say one's more important than the other, and they're not. They're all tied together, and without any of them, you don't have any freedom, and you are a slave. And by demonstrating to you, showing you what the courts have said, what history has said, and then presenting this in such a way, hopefully, that you can get a grasp on this, because most people sit there and they end up, with problems and have to go to court because the court's been, kept secret from all of us. You don't know what to do. And there are a lot of rules, and there are things you have to know how to do. And I strongly recommend that you don't ever go into court and do anything unless you absolutely know what you're doing. That was one of the things that I did for so many years, was to teach pro se litigation, so people could use the courts and use them effectively, because they're going to try to throw all kinds of obstacles in front of you, even though they'll be acting like they're trying to help you. It's a joke. It's a joke to the legal profession. They know that they have complete control over the judicial branch of government. They know that nobody gets into this club, this corporation, this fascist system that forces the citizen to waive all of their First Amendment rights, waive their Fifth, Sixth Amendment rights, and we're going to get into the Fifth Amendment right, and we're going to get. And I'm telling you, I just can't stress the importance of these different shows. Anyway, that's a quicker review of what we did here, and I show you a few examples of how it works in court. So I'm going to go ahead and we're going to move on. The next show that we will have, we'll be reading directly from cases that I have filed with court, and I want you to be able to hear how it's presented. And I'm going to see if I can't dig up the some of the records. I got some of the stuff's hard copies. I don't even know where they're at, but if I can find the Supreme Court decisions, I can show you how the courts deliberately avoid this question. They'll every time I've ever asked it, said about the assistance of counsel of choice, they immediately turn it over that no, you don't have a right to have someone who's not a member of the bar represent you. They turn it into representation as opposed to assisting. And I have, it's amazing because they do it every single time. They will not address the issue. And the issue is written clear and concise, and they make up an issue that was not even part of the appeal, and then they rule on that. And that's how corrupt they are. But anyway, if you're politically correct, then you're legally wrong. And if you're not part of the solution, then you are the problem. I'm the Ghetto Man, and thank you for watching.
She's on the dark side. She's on the dark side. She's on the dark side of the moon. She will seduce you with all her pleasures. Man or woman, she tempts them all. She is so lovely, her looks will turn your head. Come on in and sleep in my bed. Religion and greed. Spend some time and she'll plant her evil seed. She'll give you all that your heart can desire. She'll place the whole world at your feet. On the dark side. She's on the dark side. She's on the dark side of the moon. You'll think you're special, that you're the only one. She'll steal your heart just for fun. Your poison that you take with delight. You'll lose your spirit without a fight. Deception's a game. She'll drive you completely insane. She'll take all good that you could be. Step in to her evil den. Life will be nothing but torment and sin. Yeah! seduction. You'll welcome your destruction, completely consumed by power and greed. Nothing else matters as you eat from silver platters, while your soul is being served to the whore. Within the cesspool of power, a smell you can never shower. The stench of greed leaves blood upon your hand. Just like Hitler and Stalin and George W. Bush, exposed as the tyrant you really are. She's on the dark side. She's on the dark side. She's on the dark side.